Jesus Christ. Jesus Christ. So I woke up this morning and I proceeded to do more work on my appeal. So now I'm up to 63 pages. This is a very big problem. It's a very, very big problem. I'm not sure how I'm going to deal with that. But anyway, I wanted to read to you my statement of facts on my motion, my appeal. And, I want to hear myself say it so that, I can hear what errors I need to fix. So I thought I'd do it like with a video and then share it with you. It may be too long though. Let's see. Okay, so statement of facts. So the plaintiff is a lawyer licensed in the state of New York who is appearing pro se in this action. She is a dual citizen of the United States and Antigua. She is a domiciliary of the state of New York. She's temporarily living and working in France. The defendants are the British government and the British monarchy. They are continuum entities that have existed for close to millennia and that depend on agents and representatives to act on their behalf. The plaintiff contends that the defendant government and monarchy have, through their agents and representatives, arbitrarily deprived her and others similarly situated who are of Caribbean ancestry of information and data about their ethnic origins by causing their ethnic origins to be erased during the period known as slavery. The plaintiff contends that as American citizens, she and the aggrieved persons in this matter have a fundamental and constitutional right to know their origins. She believes that this fundamental right is undergirded by the Equal Protection Clause and the Substantive and Due Process Clauses of the 14th Amendment of the U.S. Constitution, as well as Section 11 of the Constitution of New York State. The gravamen of the plaintiff's complaint is based upon the defendants' commercial activities in the 16th, 17th, 18th, and 19th centuries, and the direct effects that these are having on her and others today. During the past centuries, the defendant government and monarchies, then agents and representatives, authorized, managed, controlled, and regulated the regular course of commercial conduct of their citizens in an industry called the transatlantic slave trade. This industry involved kidnapping, exiling, imprisoning, and dehumanizing millions of unsophisticated and undefended civilians who had done nothing wrong and who had not received due process before their rights, including their identity rights, were taken away. Subsequent agents and representatives of the defendants, up to and including the current agents and representatives, have had knowledge of these events, but have done nothing to restitute the injured people for more than 400 years. The plaintiff is a direct descendant of some of these undefended civilians. She contends that she does not know her origins because of the wrongful and unlawful acts of the defendants' agents and representatives. She wants the defendants to reestablish her origins by paying for DNA tests. The plaintiff contends that the Foreign Sovereign Immunities Act is applicable to the defendants. She contends that the transatlantic slave trade was commercial activity within the meaning of 28 U.S. Code Section 1603, which defines commercial activity as a regular course of commercial conduct or a particular commercial transaction or act. The plaintiff contends that these commercial activities continue to have direct effects on her and others similarly situated of Caribbean ancestry who are domiciled in and outside of the United States. The plaintiff and others similarly situated have lost all information about their ethnic origins as a consequence of the defendants' wrongdoing. The plaintiff and others similarly situated only know that they are descended from slaves from Africa. Africa is not a country. The plaintiff wants to know her actual origins, and she wants the defendants to pay for DNA tests to help her and others who have been harmed by the defendants' commercial activities during the slave trade with re-establishing their origins. The plaintiff contends that the facts and law implicated with this equitable demand are identical for all parties in the proposed class. A decision in favor of one is the same decision for all and would resolve this matter in one stroke. The undersigned, who is the plaintiff, is pro se, and she has asked for her case to be certified as a class action with her as lead attorney because she believes many of the aggrieved are legally unsophisticated persons who would not otherwise have any recourse in this matter. The district court has denied the plaintiff's request for class certification. The district court has also denied the plaintiff's motion for pre-judgment equitable relief. The undersigned contends that the district court committed reversible error and has abused its discretion by denying both motions. She seeks de novo review of both motions.